Hello, I'm Peter Afrasiabi. I'm a partner at One LLP, an intellectual property law firm with offices in Los Angeles and Newport Beach, California. Today's program is design patents. Now, there are a lot of IP programs that I've done. You can see sort of the full range of intellectual property survey classes, as you see here on our next slide. These are programs that are for litigators, for transactional lawyers, for IP lawyers, to PI lawyers, and everyone in between. And you see here a quick summary of some of the programs that are out there. If you go do a search, you'll find them. We've looked at trade dress in the shoe space and in the auto space, where we have, Ford versus Ferrari, but looking at it through the prism of trade dress law. We have an IP overview survey of really all the areas of IP law: trademark, copyright, patent, trade secret for the generalist. Even IP and due diligence in corporate transactions for you to unpackage what you need to know as a transactional lawyer. And we've even given you the ability to really learn all about copyright law, from the idea expression line to infringement to fair use to damages, all by exploring the music of U2 and using U2 as a petri dish to sort of survey everything. Programs on fair use, on Hollywood and substantial similarity in ideas in movies and TV shows, right of publicity programs from dead celebrities to defamation, looking at the Johnny Depp trials, and even voice control involving right of publicity over one's voice and likeness. We've looked at trademark law and dilution and famous brands and other programs. And then we've also used Star Wars to explore both copyright and trademark infringement principles for you, the generalist, or for the IP lawyer, and even the history of James Bond litigation, which is an intellectual property history primarily. So that's a set of different IP programs you can go to if you want to explore more IP. But for today, as you can see here, we're looking at a patent law overview, and we're going to be focusing today specifically on design patents. And so our agenda will be, on the next slide you see here, looking at utility patents and design patents to see the differences between each of them. And then we're going to focus in on design patent cases, and we're going to look at what are sort of the scope of design patents in terms of how they work. We're going to look at a variety of cases to understand what is a design patent, what's infringement, what infringes, what doesn't, how does it work, how do courts look at design patents. We're going to look at defenses to the charge of design patent infringement, which include looking at functionality, obviousness, invalidity based on prior art, that is, prior design patents that are out there. And we're also going to look at the damages remedy, which is a pretty powerful remedy when you're looking in the modern world in terms of the patent landscape, at least. In design patents in particular, in distinction to utility patents, you're going to see a very powerful remedy. And we will, as a result, as we meander through this sort of pathway of design patent law, we're going to look at a variety of different cases and technologies that'll be fun and familiar for you. We're going to look at iPhone cases, LA Gear. For those of you who are children of the 80s like me, you'll remember the LA Gear shoes in the 1980s that were so popular. They spawned trade dress battles, and as we're going to see here today, design patent battles. We're going to look at Crocs, those shoes that became popular not in the 80s, a lot later, but nonetheless popular, and see how they've fared in the design patent world. Even back to the origins, spoons, cutlery. That's what started the U.S. Supreme Court in the design patent world. We're going to go back and look at that old case. And then we're going to look at modern stuff like Nike shoes and design patents, and even Columbia Sportswear and the heat insulation in the jackets that we wear. And along the way, you'll see in yellow on different slides some practice pointers, which are some of the distilled ideas, practice tips for you as an IP lawyer, as a patent lawyer, as a generalist, just counseling your clients in terms of things you can advise your clients to help them perhaps create more value, unlock more value out of their business in terms of thinking about patents. As an overview of patent law, you're going to see here on the next slide, let's start by just unpackaging the difference between what is a utility patent and what's a design patent. And these are the two camps that you as a lawyer or for your clients can go and get a patent. They can be utility or design. And a utility patent, in distinction to what we're talking about today, which will be design patents, of course, a utility patent protects what an invention does and how it does it. And so that is the detailed function of a product, So think about things like machines, an engine, a computer, things made up of moving parts. We get utility patents on processes such as software, composition of matters even, such as drugs and the modern chemicals that are being patented for the Marvel drugs that we all get to take to hopefully live long, if not living forever. And even articles of manufacture themselves, candle holders, for example, just a product in commerce. Now, design patents, in distinction to this idea of protecting the function of a product, a design patent protects what an article of manufacturing looks like. That is, its distinct shape, its style, its configuration, its cool look, you could say. And so this unique ornamentation of a product is what is protected, not its operational functionality. And so a way to think of this is the famous example of an old design patent. You see, we have it here reproduced for you. The Coca-Cola bottle. It's a very unique, distinctive, cool-looking shape. At least the Coca-Cola company thought so. And they got a design patent on it, way back in the day, in terms of that cool ornamentation. And so what that means is, because it's protecting the ornamentation of the product, they were the only ones allowed to make a glass bottle that holds liquid that's got that kind of cool Coca-Cola looking shape. Now, it did not protect, of course, the functionality of the product, i.e., by getting a design patent on that cool looking bottle, they weren't able to control the function of a bottle, something to hold liquid, obviously. And so that's where you see the distinction between design and utility at sort of 30,000 feet as we're getting going here in terms of where we're going with designs. And so a patent, of course, must be secured from the federal government through a process called patent prosecution. And this is basically an interaction that the patent lawyer has with the patent examiner to define and argue about what's the invention, what's patentable, is it impatentable, etc. And if it's issued, the term of utility patent is 20 years, and the term of a design patent is a little bit shorter, it's 15 years. Now, the claims, of course, ultimately are what we're talking about in patent law. They define the invention. And so you can see on our next slide here the idea that utility patents have claims that are literally written out in language, and that's sort of the metes and bounds of the invention. And it's a set of words that are written in the English language that define the patentable invention, that define what the invention is, and then there's, as you can imagine, endless litigation down the road over what those words mean, the same way we fight over what the words of a contract may mean. Now, design patent, in distinction, is a drawing, and the claim is the drawing. It's, as you saw in that Coca-Cola bottle, it's the picture, it's the look of it. It's not defined by words. So one doesn't say that I am claiming a design patent in a bottle that's got a cool, curvy, wandy look and feel to it. And then future jurors, for example, have to figure out what those words mean. The design patent instead is defined by the look of the thing itself, not the words. And so it's very simply a picture. And so you can see here on our next slide, we are looking at two different really examples of these patents. One on the right is a design patent, and the one on the left is a utility patent. The utility patent is one that I pulled, it's one that I've actually got myself on an invention, ciceronow.com. You can see the metes and the bounds are there written, and this is a digital overlay system comprising and you can see there's a whole bunch of verbiage there that I'm not going to read to you, but that is literally a patent I've received myself, and it defines this invention of this digital overlay for using with Zoom and for persuasion software and the like for our Zoom presentations. And to figure out what the invention is, one has to unpackage all of those words. Now, when you go to the right side of our slide here, you can see a design patent. And that's a design patent on a pair of cool-looking sunglasses. And there are no set of words that are describing the sunglass invention for a design patent, unlike a utility patent on the left. Instead, it's simply, the design patent will say, a pair of sunglasses that looks like the following. And then it's got a whole series of pictures. And those pictures become the metes and bounds of the invention. And so, utility is words, design is written words. And so we will dive deeper into design patent, an overview of the law, to understand how we then go about getting a design patent on an article of manufacturing. And you see here on our next slide this set of principles that we will start with in terms of unpackaging a design patent and unpackaging what it is. Design patent protection is available for a new, original, and ornamental design for an article of manufacture. And that comes from 35 U.S.C. section 171 and 103. This is just the U.S. Patent Code. And so a patentable design will give a peculiar or distinctive appearance to the manufacture or article to which it may be applied or to which it gives form. And this comes from the seminal case of Gorham Company versus White. It's reported at 14 Wall 511, 525 from 1872, very old U.S. Supreme Court case. And that very principle about protecting peculiar, distinctive look and feel to an article of manufacture has been the litmus test really since the inception of design patent law, and it's still true today. And so what this means on a second bullet point you see here is that new, original, and ornamental, what it ultimately means is the non-functional aspects of an ornamental design that were not obvious at the time of invention to one of ordinary skill in the art at issue. And that's sort of the overarching framed principle for what it takes to get a design patent. Now, what's important here, remember, because we are talking about design patents, is that you cannot claim the structural or functional aspects of the article via a design patent. In other words, you can't come up with a really cool looking bottle, get a design patent on it, and then claim the functional aspect of, a container to hold liquid to therefore try to get a monopoly over sort of the world of bottles. Therefore, as a result, design patents protect non-functional characteristics of a design, even if the overall product still has a functional purpose. And so for design patents, the product design must have been primarily for the purpose of improving that appearance, not the use of the product. So the cool shape to the bottle doesn't improve the function of the bottle, it's just a nice looking ornamental appearance. Now, on the other hand, if the design is dictated by the function, then it cannot get protection. The contrast, of course, is utility patents, which do in fact protect functional ends. So here's a practice pointer to think about for you as general lawyer, for your clients. Think about getting both kinds of patents for overlapping protection. Many times clients will come and get a great utility patent, and at the same time they could get in addition a design patent that covers the look and feel, so to speak, the design, the ornamental nature of that very cool functional invention that they've made. And for an small additional amount of money, there can be great value in having overlapping protection. So you can see here, we're looking at the Egyptian goddess case, which is really the seminal case coming from the Federal Circuit dealing with how we go about addressing and defining what exactly is the claim of a design patent. And so it's the case of Egyptian Goddess Incorporated versus Suissa Inc. It's reported at 543 F. 3rd, 665, and it's from the Federal Circuit in 2008. The Federal Circuit, of course, is the Federal Appellate Circuit Court of Appeals that handles all the appeals from all the district courts in the country dealing with patent cases, and it's got exclusive jurisdiction over patent cases. So it's the one federal court, actually, that is sort of a specialized court only for patents. And so it gets all the utility and design patent cases. Egyptian Goddess, then, is sort of the seminal case today that makes the point that we look to the pictures, not words, that are used to describe an invention, and we define it as follows. A design is better represented by an illustration than it could be by any description, and a description would probably not be intelligible without the illustration. So that is the core principle sort of claim construction, of how we construe what the meaning of a design patent is. And so it's done by looking ultimately at all the figures of the patent. And so you see here on our next slide, there's a picture of a shoe, and this is an actual design patent on the sole of a shoe. And basically what happens is you submit a whole bunch of pictures of your ornamental design, and the figures that are ultimately issued by the government in terms of your ornamental design patent protection, they define the claim. Broken lines in the design are not part of the claim design. It's just sort of the non-broken lines part. And this is a basic case in re Matita, 900 F. 3rd, 1369 from the Federal Circuit in 2018. And the point is that they make, you see the quote there, but the fact that shoe bottoms can have three-dimensional aspects does not change the fact that their ornamental design is capable of being disclosed and judged from a two-dimensional plan or planar view perspective. So what's the point here that's really important? We think of shoe tread, right, as being, it is three-dimensional by definition, and it's very functional also by definition in terms of what the tread does in terms of gripping the ground and all that. But a patent, design patent, can still issue on this, what is a two-dimensional depiction of the shoe tread, even though it's three-dimensional. So you could imagine the simplest one, just maybe like 9 little circles of tread going down that would look like a ring of circles, for example. And it may exist in three-dimensional form, but it also is visually discernible to the human eye as just a design, right? That is what a claim of a design patent can give. Overview, though, requires us to start really unpackaging, okay, so you've got a design patent. What does it mean to infringe a design patent? This overview is going to take us, as you see on our next slide here, to that seminal case I mentioned of Gorham versus White, 81 U.S. 511. This is the quote from page 528, and the case comes from 1871, barely after the Civil War, right? But it's the same principle we're operating with today. And Gorham started with a design patent that the plaintiff Gorham had, and you can see there a picture of Gorham's spoon. This is sort of the cutlery spoon case. This is where it all began, ladies and gentlemen, with spoons in the United States design patent law. And pretty soon you're going to see where it all ends, with Apple, Samsung, and our smartphone battles. That's part of where we're going, and everything in between. But take a look at Gorham's spoon there, 1861, he got a design patent. Now, White came along and got some design patents too on White's spoons. Gorham was unhappy and Gorham sued, saying, your designs of your products, those spoons being sold, they're too similar to mine. They infringe my design patent. And so here's the rule of law from the US Supreme Court in 1871. We hold, therefore, that if, in the eye of an ordinary observer, giving such attention as a purchaser usually gives, two designs are substantially the same, if the resemblance is such as to deceive such an observer, inducing him to purchase one, supposing it to be the other, the first one patented is infringed by the other as a result. Now that's the basic test. This idea of an ordinary observer is going to be conned or tricked into thinking that, they're getting something that belonged to the plaintiff of the design patent. And so here's what the court held then when looking at Gorham and White's spoon designs. Both the White designs, we think, are proved to be infringements of the Gorham patent. A large number of witnesses familiar with designs, and most of them engaged in the trade, testified that in their opinion there is no substantial difference in the three designs, and that ordinary purchasers would be likely to mistake the White designs for the cottage, that is the design of the plaintiff, the Gorham cottage one. So that, you can see, is the holding of the court then in terms of how ordinary observers may perceive and discern the difference between those spoons. And it was based on that evidentiary record. Here's the question for all of you, though. Looking at it today, given the number of spoons that are out there, and millions of spoons and that we all buy and sell every day, do we think in today's day and age an ordinary observer would be so deceived and confused? I mean, would the record look the same today? It may not 150 odd years later, just given the nature of how much more commerce there is, the ubiquitous number of spoons, forks, shoes, cars, you name it, that we all engage with every day, which wasn't as well developed commerce, obviously, back in the 1870s as today. It may not come out the same way today, but it may. If you had the evidentiary record built that established that point, maybe a jury would believe it. And so what we're going to see as we get going, though, is that today, a lot of this hinges ultimately on a lot of expert testimony to figure out surveys of consumers to try to understand what ordinary observers would think. Part of the overview, of course, then takes us to what happens if you prove infringement. And this gets to the question of damages. And so you see on our next slide here, we're looking at this overview of design patent damages. And so here's the US Code, what it says, and we're going to unpackage it soon. A person who manufactures or sells any article of manufacture to which a patented design or colorable imitation has been applied shall be liable to the owner to the extent of his total profit. 35 USC section 289. Pause there, double click. His total profit. Literally, the total profit that the defendant may make is now owed to the plaintiff for an infringement of a design patent. Now, if you stop and think about that, that could be a heck of a lot of money. And the contrary case to look at is what happens with utility patents. Utility patents do not get such a potent remedy. Utility patents allow a plaintiff to get either a reasonable royalty or their lost profits. And so we look at sort of profit margins that come from that product, or what would a reasonable royalty be to sort of license the invention. And invariably, those numbers are less than the total profits a defendant may have made. You just can't get such a potent remedy. And so you see here this practice pointer again, that because we have such a powerful damages remedy with design patents then become a very potent tool for a company to have to fundamentally address infringers. And so it really is one of the more substantial remedies in all IP law. When you look at patent, trademark, copyright, trade dress, right of publicity under state law, and all the different remedies that are available, this design patent remedy is one of the more powerful ones, because total profits of a defendant's profits can be a staggering sum of money. And so the practice pointer for you fundamentally is, and this loops back to our earlier practice pointer, when you're thinking about helping your clients who are engineers, maybe they've come up with an invention, it's functional, they're going to go get it, stop and think about how that thing is going to look. How is it going to work in commerce? Can we get a design patent on it? May people want to infringe it, not just for the functionality, but for the design? May it be inevitable to take the design? If that's the case, you may want to get a design patent in order to have this powerful remedy to shut down infringers. Now, we're going to start shifting from spoons to iPhones. And so you see here on the next slide, Apple versus Samsung, and this is episode 1 in our infringement wars of the day. This is the Apple versus Samsung case reported at 786 F3rd 983. It's from the Federal Circuit in 2015. And you see there are pictures, and we've got the pictures of the Apple design patent on the look and feel of the iPhone, and we've got Samsung's accused products being the verbiage in patent law of the alleged infringing products. So those are the Samsung Galaxy phones and whatnot that were accused of infringing this Apple design patent on kind of the look and feel, the shape, so to speak, of Apple's smartphone. So what happens? Apple, of course, comes out with its iPhones, immensely successful, changed our whole cell phone world, right? We're no longer using our flip phones and the Razor phones and the like that we had back in the day, and our Blackberries have certainly gone the way of the dodo bird. Apple comes out with it, Samsung wants to catch up, and Samsung then starts coming out with its sort of Android-based phones that look very much like an Apple phone. And to many of us, they all look the same. So Apple, not happy, it's got its design patents, so it sues Samsung over the smartphone's shape, the look and the feel. Case goes before a jury. This is up in the Northern District of California. The jury finds liability. Now, Samsung had argued that the rectangular form and the rounded corners were really dictated by function, and so they should have been excluded. This was rejected because the ornamental aspects, they may perform a function, i.e., whether it's round or square, it performs a function. It holds the shape of the phone, right? But it's fundamentally part of the design. It's not a functional patent. It just happens to be able to perform a function the same way a bottle happens to hold liquid. But the unique shape of the bottle is like the unique shape of the iPhone. And so what happened is Samsung's defense of this not really being ornamental, this being functional, was rejected. The jury found then that Samsung was liable for infringement. Now, let's talk about what the infringement standard is. And so you see on the next slide here, we're going to recall again that ordinary observer test, because I want to put it back in your mind again as we continue to walk through the episode 1 of the Apple Samsung battles here as we do our design patent walk. The infringement test that the Apple Samsung jury had to apply is the following, and it applies to the construction given the ordinary observer test that posits that a design patent is infringed if the accused article is substantially the same as the claimed design in light of the prior art from the perspective of an ordinary observer who is a purchaser of the type of goods accused of infringement. Again, remember, Egyptian goddess, Gorham, same basic test, eye of the ordinary observer. So, as we're back on now, we have that in our firmly planted in your mind. Let's look again at our pictures here on the next slide. We see again the Apple and the Samsung products. And on infringement, again, Samsung said, look, an ordinary observer would look at the two phones and they wouldn't confuse them. You know, phones are phones. You know, the Apple phones are sufficiently different to our phones that no one's going to be particularly confused. They'll recognize one's an Apple, we're not, right? That was their basic argument, factually, that ordinary observers just aren't going to confuse the two. What did the jury hold? Well, ultimately, and what the Federal Circuit held when it got the case on appeal, describing what happened at trial in the jury, and here's what the Federal Circuit said as it described the jury and the jury's findings. The witnesses testified on the similar overall visual impression of the accused products to the asserted design patents, such that an ordinary observer would likely be deceived. Apple's experts also testified about the differences between the asserted patents and both the prior art and other competing designs. The jury could have reasonably relied on the evidence in the record to reach its infringement verdict. And so what the Federal Circuit said is, look, you go before a jury, you take your shot, Samsung. When you lose, you lose. And here we have witnesses, so that there was actual percipient factual testimony saying, yeah, these things look the same. You know, overall, they're sufficiently similar. And there are other non-Samsung Android-based phones out there that are markedly different from Apple or sufficiently different from Apple that it puts you, Samsung, too close in the orbit of Apple. You're not distinguishing enough. You're sliding into them to replicate that cool Apple look and feel that's been so successful for Apple. Expert testimony was also given, as you see there in that quote, which is really important because expert testimony becomes very, very important to unpackage the design patent, the accused products, where the other products in the marketplace are, how you line them up in this constellation or this spectrum, and also to survey consumers to understand perceptions of these products. And remember, this is the average, reasonable, ordinary observer purchaser who goes out and buys this stuff. This is not sort of techno geeks who are, super specialized and obsessed about phones who can always tell the difference between everything. It's, your mom, your dad who are just going to pick up the next phone type person. And this is very, very important. And again, this is what makes design patents so potentially very, very powerful. But they don't just cover computers, smartphones, high technology. They cover spoons, as we saw, and they even also cover the shoes that we wear. Now, we saw a shoe earlier, but now you see on the next slide here, we're going to look at the Croc Wars to see what happened when Crocs came out, and we all remember I guess it must have been the 1990s. I think they came out, maybe it was the 2000s, dating myself because I can't even remember now, the decades are starting to blur. But they came out immensely powerful, successful in the marketplace. Everyone was wearing Crocs for a while, right? And there, you see there our picture on the left of the design patent that Crocs got on their shoes. And they're these cool looking plasticky Dutch-like sandal beachy shoes with a strap around them and some holes on them and this kind of distinctive, shaping, design, look and feel. So the red ones did not make the Croc company happy because the red ones were being imported into the US and being sold, and the Crocs company felt those are infringing. They look the same. I mean, look, they look the same. Now, let's just pause there. We looked at those spoons. I mean, they look the same in the sense that they were spoons, but they had similar ornamentation, but maybe a little bit different. Those infringed. The question here then is, what happens here? The ornamentation, it's similar. Is it identical? No. But is it similar? You kind of feel the look in the same, maybe. I'm not a Croc expert. I looked at it. My first blush is it all looks the same to me. So Crocs felt the same way. So they bring the case to the ITC because they wanted to stop the import. What did the ITC say? Well, the ITC looked at Crocs shoes and said the claims, so to speak, your pictures, have non-uniform strap and evenly spaced holes. And so if you start unpackaging that the look and the feel of those pictures, you realize, okay, they're they're evenly spaced holes of a certain kind, in a certain shape, in a certain way. And so what the ITC said is, look, there's no infringement. The red strap has uniform width. The Crocs strap it gets bigger, right? The strap is narrow at the base where it connects to the shoe, and then it gets wider as it goes around the heel, and then it gets narrower again. And so that makes the strap sufficiently different that it doesn't infringe. And they said, and look, Crocs, look at your holes. Your holes are evenly spaced around the sidewall, theirs aren't. Your holes are round on top, theirs aren't. And so these minor differences made it not infringe. Well, you can imagine the Croc company was not happy, and so they decided to take that up to the Federal Circuit Court of Appeals. And you see on our next slide here, this is at 598 F 3rd 1294, page 1306. It gets to the Federal Circuit in 2010, and the Federal Circuit reverses. And the Federal Circuit says, look, ITC, you gave undue emphasis to these verbalized small differences. And when we say verbalized small differences, what we're saying is, you took the picture, you converted it to English language and said, well, but the strap's wider, the holes are uniform. And you, in essence, transmuted a design patent, which is on the design, the look, the feel, the overall look, to a set of words, which then included a strap that's not uniform, holes that are uniform, and those things. And then you compared that verbal incantation of the design to the other side, and you said, oh, well, they're not the same. And that ends up getting away from the real test, which is, how does an ordinary observer just looking at the two feel about the overall similarity? And so here's what the Federal Circuit held. These side-by-side comparisons of the 789 patent design and the accused products suggest that an ordinary observer familiar with the prior art designs would be deceived into believing the accused products are the same as the patented design. In one comparison after another, the shoes appear nearly identical. If the claimed design and the accused designs were arrayed in matching colors and mixed up randomly, this court is not confident that an ordinary observer could properly restore them to their original order without very careful and prolonged effort. And so you see what's critical here then, and this is again, why it's so powerful to have a design patent if you can get one. An ordinary observer is not going to make these, mechanistic, legalistic, hyper-technical, parsing of products in the marketplace. They're just going to look and say, overall, big picture, does it look the same? And if you were to mix them up, could I even unpackage it? Probably not. Boom, done. Case over, right? It's like the spoons. Now, the other side of this, of course, for those of you who may be representing people who want to start a new business, they're entrepreneurial, they've got a little capital put together and they want to make shoes, and they come along and say, hey, look, I'm making this cool shoe. Yeah, it's kind of like a Croc, but it's different. I'm going to make this change, make that change, make this change, make that change. Be very, very careful is the advice. Don't do it, because making technical or hyper-technical changes in a product to get around a design patent may or may not work because of this ordinary observer test. And the ordinary observer test then, to plaintiffs, lawyers on the patent side, stuff that we do in litigation, it's broad enough that, you can drive a truck through that kind of a hole, right? It's a big hole that you can build a case out of. So be very, very, very careful on the defense side of design patents, and, don't try to take the look and the feel in order to get around it unless you get some serious legal advice on the front end, and maybe even a letter to try to protect you from willfulness. Now, we've talked a lot about infringement today, about how you look at the claims of a design patent, how you figure out if they're infringed. And we talked in the beginning about functionality, and that is that you don't get to protect functionality. But we also have to unpackage a little bit more what is functionality. And that brings us to our next slide here, you see. And this is when we're talking about defenses, where a defendant gets to say, that's great, you got a design patent on that look and feel, but it's functional. And so it's invalid for functionality. So let's unpackage functionality a little bit. Unlike utility patents, design patents don't, indeed they cannot, include claims to the structural or functional aspects of the article. To understand this, you can just go look at Bonito Boats versus Thundercraft Boats. This is a significant case that went up to the US Supreme Court in 1989. It's at reported at 489 U.S. 141. This quote comes from page 148. And the Supreme Court simply said, to qualify for protection, a design must present an aesthetically pleasing appearance that is not dictated by function alone. That concept is that this ornamental aesthetic look cannot be driven by function alone. Hence, Crocs could get a design patent because the function of a shoe wasn't saying that you have to have a strap of that shape and size or holes in that area. It wasn't function alone that dictated it, right? So that's why they were able to get one. And so you see this functionality standard, it's a high standard, it's a high bar. We can look at this case from 1997 from the Federal Circuit on our next bullet point. It's called Hupp versus Ciroflex of America, 122 F. 3rd, 1456. Here's what the Federal Circuit said on functionality. Although the design patent is directed to the ornamental aspect of a useful article, that the design of a particular article is related to the article's use may not defeat patentability. When the design is primarily ornamental, although it also serves a utilitarian purpose, this design patent condition is met. Pause there, double click. When the design is primarily ornamental, even if it serves a utilitarian purpose, go back to our Crocs, it was primarily ornamental, although fundamentally at the end of the day it was serving a utilitarian purpose. It's a shoe that you wear on your foot to protect your feet or to get around, whatever, right? But nonetheless, you can still get a patent on it because, let's keep going with the quote from the Federal Circuit. After the ellipses, you'll see, the fact that the article of manufacture serves a function is a prerequisite of design patentability, not a defeat thereof. The function of the article itself must not be confused with functionality of the design of the article. And so that line is very, very important, and it's a line that makes the functionality defense a hard one. So invalidity, as you see on our third bullet point here, due to functionality, is ultimately an affirmative defense to a claim of infringement. It's on the burden is on the party asserting the defense, i.e. the defendant. There is a presumption of validity of a design patent. That's at 35 U.S.C. section 282. And so you have not only the issuance of the patent, you've got this legal presumption that it's valid, and the defendant then has this burden to overcome to prove that the patent's invalid due to, for example, functionality or another defense. And that burden isn't just a preponderance either. It's one that requires clear and convincing evidence. So the practice pointer here, of course, is don't think that you can just easily invalidate a design patent on functionality grounds. The patent prosecution process weeds out clearly functional ones most of the time. Of course, some do get through and we'll have a functionality defense that can be made against them, but it's never a slam dunk. It's never easy. So, again, tread carefully as a potential defendant around design patents is the best advice. We're going to stay in the shoe realm, but this time we're going to go from Crocs back to the 1980s. I'm a child of the 80s, and so I remember these shoes you see on our next slide here. LA Gear. I remember they were all of a sudden the biggest thing. It must have been 85, 86, I can't remember, somewhere around there. But I remember everyone had them, everyone had to have them. I wanted to have a cool pair of these high-top LA Gears to be the cool kid on campus in high school. And LA Gear, of course, was immensely successful, hence we remember them. And so at the time, it was sort of a big deal to have these shoes. And so someone decided they were going to make some similar ones. And this brings us to the case of LA Gear versus the Tom McCann Shoe Company. And it's reported at 988 F. 2nd, 1117. And this case went up to the Fed Circuit. And by the time it had gone to trial and got up to the Fed Circuit, we were now in the 90s. And at least I wasn't wearing LA Gear in the 90s anymore. But I don't even know if they were still popular by the time the case got resolved. But nonetheless, we're in 1993. And this is what happens in the case. So the defendant made, you see at the bottom there, those shoes. And, other than one saying LA Gear and one saying balloons, they look basically identical, if not almost literally identical, but very, very similar. And the defendant wanted to capitalize on the success of LA Gear and make similar of these sort of high-top shoes. They called them balloons. LA Gear, not impressed, they sued for design patent infringement. Now, at summary judgment, the defendant argued, and they had experts, that the aspects of the shoe of LA Gear's design patent, they were functional. For example, there's that wing that crossed over that holds the foot down, kind of this strap that goes around the front. The side mesh to the LA Gear shoe gave support. The back mustache-shaped heel gave support. And that was their argument. We spoke a few minutes ago about functionality. We saw those principles. And so you probably are guessing right now how the Fed Circuit was going to hold, what the trial court was going to hold, and what the Fed Circuit was going to say. And here's what they held on the next slide. It was ornamental, not functional. And that goes back to what we were saying. Yes, of course, mesh on the side serves a function in a sense. It keeps the shoe together. But it wasn't the primary reason to have the mesh in that location, place, and whatnot. I mean, there's a million ways to have support. And so this is the point, and you see the quote here from the Fed Circuit, that elements of the 081 design, the 081 being the LA Gear design patent, such as the delta wing or the side mesh, also happen to provide support for the foot, doesn't mean that the specific design of each element and the combination of those elements into the patented design is dictated by primarily functional considerations. The district court remarked on the existence of a myriad of athletic shoe designs in which each of the functions identified by Melville, that was the defendant's expert, as performed by the 081 design elements was achieved in a way other than by the design of the patent. In other words, there's loads of shoes out there that have a heel of some shape, meshing or leather or whatever on the side, a strap that goes over. There's 1,000, a million, a billion ways to do that. And so where there are several ways to achieve the function of an article of manufacture, the design of an article is more likely to serve a primarily ornamental purpose. Very, very important principle then for functionality. And that is that, yes, of course it serves a functional purpose in part, but when there's 50 different ways to achieve that function, then a particular design of one mechanism to achieve the function may indeed be driven for ornamental purposes, not dictated by function. In other words, if it was dictated by function, it would be kind of the only way you could do it, because that's the only way to achieve the function at issue. Very, very important principle, a very brutal lesson for the balloon company, who were found to infringe, and it was affirmed by the Federal Circuit. Now that's functionality as a defense, but there are other defenses, of course, that I alluded to in the beginning. One of them is obviousness. And obviousness is a defense to both utility and design patent infringement charges, again, that can be asserted by the defendant. And you see on our next slide here, we're going to look at some of the principles of obviousness in the law, and then we're going to explore the application of them. We're going to continue, though, with LA Gear, because LA Gear also made an obviousness defense. But let's start with the first principles. Design patents must be non-obvious to be valid. That's just the basic principle. But what does that mean? Well, here's the quote from LA Gear at page 1124. Obviousness vel non is reviewed from the viewpoint of a designer of ordinary skill or capability in the field to which the design pertains. As with utility patents, obviousness is not determined as if the designer had hindsight knowledge of the patented design. When the patented design is a combination of selected elements in the prior art, a holding of obviousness requires that there be some teaching or suggestion whereby it would have been obvious to a designer of ordinary skill to make that particular selection and combination made by the patentee. Tough standard, as you can see, just substantively divorced from any application. And so here, what they held is that the defendant's expert offered 22 different prior art references where they said you can look at all these other shoe designs and you see all the various features that LA Gear had and had got a patent on, and they were all there. And so you can reconstruct the LA Gear shoe, plucking all these different pieces from different prior arts. One shoe had a heel like this, that other shoe had mesh. You could have put them all together and got LA Gear, right? That's what they were trying to say. And so they were saying it's therefore obvious. Not so, because what the Federal Circuit said is that, it's not enough to do that. And I bolded the quote for you. A reconstruction of known elements does not invalidate a design patent, absent some basis whereby a designer of ordinary skill would be led to create this particular design. In other words, in order to invalidate it, it had to be that anyone of ordinary skill would have said necessarily those three must come together in this way. The three elements we're talking about there. And so the district court concluded there was no teaching or suggestion in all those other shoes that the LA Gear one had to become the appearance of the design simply by virtue of that prior art. So One of the key points that comes out of this for your clients that sometimes, I've noticed over the years, many, small businesses, engineers and whatnot, they think that anything they come up with will be obvious, or they think, well, you can't do that because, there's this element here, there's this element there, there's this element there. And one of the key points here is that you can actually take known elements and reconstruct them into a completely new creation, and that can actually get you a viable patent. So even if you've seen a cool looking heel, cool looking mesh, a cool looking bridge on 3 different shoes, putting them together in one shoe, even though you didn't invent all 3 of them individually, the selection and arrangement can itself become patentable. So don't think that what you haven't done isn't worthy of a patent. That's kind of the lesson to many engineers and small businesses when you're talking to them, because when you talk to patent lawyers like the patent prosecutors at my firm, you can get patents on a lot of stuff that you would never think you could get a patent on. Now, we also have to go, we've done functionality, we've done obviousness, we've got to touch on invalidity, and what does that mean? And invalidity being prior art. Other patents, we alluded to them earlier in terms of obviousness when you look at other patents or products out there. Now we're going to look at a more specific version of it called invalidity. And this is on our next slide. You see here the Columbia Sportswear versus Cyrus Innovative case. This is a 2023 decision, from the Federal Circuit, reported at 80F 4th, 1363. And so you see there on the right 2 pictures. The one on the top is a design patent that Columbia had on its sort of mesh lining, this sort of heat reflective material. For those of you maybe have a Columbia ski jacket or light hiking jacket, you may recognize that kind of look and feel of the mesh in the Columbia design in its jackets. The bottom is the defendant's one that Columbia alleged infringed. It's heat reflective material. And so Columbia, not happy, sues. It says, I've got a design patent on this heat reflective material for our clothing. This other company, Cyrus, they also make gloves and products that are like our products with a very similar material. And what the jury found is that given the near identical appearance of this heat reflective material, infringement was found. And so as a matter of law, that was found by the judge at summary judgment. And so the jury then, the trial was set really to only address, is it a valid patent? And what are your damages for the infringement? And so here's the prior art. On our next slide, you can see from the Columbia Sportswear case, the quote. And this is the basic principle of law and rule that you need to know for this overview of prior art and invalidity. To qualify as comparison prior art, the prior art design must be applied to the article of manufacture identified in the claim. We apply this requirement to comparison prior art for a few reasons. First, doing so best accords with comparison prior art's purpose. In an infringement analysis, that purpose is to help inform an ordinary observer's comparison between the claimed and accused designs. Designs that necessarily must be applied to the same article of manufacture. Naturally, prior art designs will help in that comparison only to the extent that they too are applied to that article of manufacture. This is a very important holding that the Federal Circuit came down with in 2023, clarifying this area of the law that had before been a little bit unclear. And the lack of clarity was, okay, I've got this heat reflective design patent, for this look and feel of this material for clothing. Someone comes along and says, well, wait a second, that similar shape and design, that's also on tire tread. And so there's a tire patent out there that would invalidate it. And what the court is saying is, no, that kind of a patent wouldn't count. It needs to be prior art in the same article of manufacture at issue, heat reflective material for clothing. And so as a result, they reversed the case and they sent it back to the trial court to do a new invalidity analysis with a narrowed realm of prior art to make sure that it attached to the actual article at issue. Now, that also meant, I mentioned there was damages to be addressed. And so this brings us to damages and how to get them. And it's very, very important to understand that powerful damages remedy we were talking about. There's a corollary requirement of marking. And so you see on our next slide here, we're going to take a quick look at damages and marking. Damages, again, the remedy is powerful. Whoever during the term of a patent for a design without license of the owner applies the patented design or any colorable imitation thereof to any article of manufacture or to sale, or sells or exposes for sale any article of manufacture to which such design or colorable imitation has been applied, shall be liable to the extent of his total profit, but not less than $250, from the U.S. District Courts. Again, remember, bigger, powerful remedy than in utility patents. But, and this is very important, you must mark the patent number on the article to be eligible for infringement damages. And so you either put it on the actual article itself or somewhere in the clothing, for example, on the heat shield, it may be, or on the label in there, or on the packaging of the product, on your website for sure. Different places, you can talk to patent lawyers about your given product. On shoes, soles, for example, you'll often see embossed in the sole the patent number so that they've marked properly. And so very, very important for you is look at your client's product portfolio. Many times, I know I've run across many small companies, they come to us for advice. They've gone out and got design patents, and sometimes remarkably they haven't marked. Or sometimes we're suing, we're suing folks, and we find they assert back design patents against us, but we realize, wait a second, you haven't marked. Marking is critical to even be able to get your damages remedy. It's just prerequisite. So this brings us to Apple, episode 2, Samsung, the battle continues, because it raises a question for damages. What is an article of manufacture exactly? What are you getting the profits on? And so in the Apple-Samsung case, as we revisit it, remember the Federal Circuit here said that the entire smartphone, the question is the entire smartphone the article of manufacture to calculate damages, or is it only the shell of the phone that's the article of manufacture, so that you'd only talk about the profits that come from the shell and you'd ignore the profits of all the innards. And the innards, of course, generate a lot of profits for a phone because there's chips in there and computers and technology. That's why it costs $1,000. It doesn't cost $1,000 just to have this, plastic or titanium, curved case, right? That was the big question. Apple was saying, we get profits on the whole phone, even if some of the profits come from Bluetooth technology and, this computer chip and that computer chip. That was the big question. And so what the Federal Circuit had to address is, what do we do? And so the Federal Circuit's standard, they said then, is that there's 2 steps. You've got to identify the article of manufacture first, and then you got to calculate the total profit made on that article of manufacture. And so what you see on our next slide here, what they held is that in the case of a multi-component product, the relevant article of manufacture must always be the end product sold to the consumer, or whether it can also be a component of that product. That's the question. Under the former interpretation, a patent holder will always be entitled to the infringer's total product from the end product. So under the latter, you'd be sometimes entitled to the total profit from a component of the end product even. The text resolves the case. The term article of manufacture encompasses both a product sold to a consumer and a component of the product. So understood, the term article of manufacture is broad enough to encompass both a product sold to a consumer as well as a component of that product. A component of a product, no less than the product itself, is a thing made by hand or machine. That a component may be integrated into a larger product, in other words, does not put it outside the category of articles of manufacture. And so what that means is that Apple didn't get the absolute conclusion that everything in the phone per se is an article of manufacture, so you per se as a matter of law get the profits on everything. They didn't win on the outer claim. Samsung didn't win on the claim that you can only get profits on the shape part of it, nothing on the inside. Federal Circuit said it's going to be more complicated, it's somewhere in between, but critically Apple won in the sense that Samsung wasn't able to hold them to never getting profits on components. They could potentially get profits on components. And so the case got sent back, and this has gone up to the U.S. Supreme Court, this case. It gets remanded all the way back to figure this out. And so the Solicitor General had offered the U.S. Supreme Court, when the Apple-Samsung case made it to the Supreme Court, a 4-factor test to use to figure out, are you going to give it on the components that are or not sold separately? Yes, no, maybe, what do you do? So it's a multi-factor test that they had proposed, and this is a test which has now been adopted by the district courts around the country and by the Apple judge on remand. And so you look at the scope, the design prominence, the conceptual distinctness, severability of the components, so that you can really figure out what is a relevant article of manufacture. Is it the whole product, just a subcomponent, which subcomponents, so that you can then figure out the infringer's profits and to figure out damages. And so that means it's elastic. Again, another reason it's powerful for plaintiffs. And so you can see what happened here on remand on our next slide with the judge in the Apple case. Went to these 4 factors: scope of the design claimed in the patent, including the drawing and any written description of the drawing, the relative prominence of the design within the product as a whole, whether the design's conceptually distinct from the product as a whole, the physical relationship between the patented design and the rest of the product. So you look at all these things and throw it into the hands of a jury, let them stir up the pot and figure it out. So at the new trial, Apple said, the profits you made on the whole phone, we get all of them, and it's $1 billion. That's everything. Every little component, profitability across the board. Samsung argued to the jury, no. Really, it's only the profits that come from sort of, you make the cover, the shape of the phone, that has a certain cost, you get a certain profit margin on it, and so we've taken $28 million from you. The jury looked at it, gave Apple $533 million. So a huge loss for Samsung, huge win for Apple, not the billion they wanted. But the key point here is that damages under this 4-factor test can be massive. And so again, it's critical for plaintiffs and defendants to be very, very careful of this so they don't get tagged with significant liability for tripping a mistake. And again, go get those design patents for your clients if you haven't already. Marking. Remember I said you got to mark in order to get your damages. It's really, really important. We're now going to go back to a shoe case to look at what happens if you don't mark your patent number properly for damages. Really quick here, now we're dealing with Nike. Nike's unhappy. Walmart's selling a shoe that some third party had made that Nike felt was a complete knockoff of its design patent on its shoe. You see there its design patent. Nike goes to trial. It was an identical shoe, basically. It was a knockoff. Nike wins on design patent infringement, but it had a marking issue. Nike hadn't fully marked all of its shoes with the patent number. The district court said, well, the marking requirement didn't apply to damages claims, only disgorgement of profits claims. And Nike was after, a non-disgorgement of profit damages remedy. Federal Circuit said no, the marking requirement applies to all kinds of financial damages claims. And so it got remanded to figure out, did they mark properly? And if they didn't, what categories of shoes are we going to cut out of the damages analysis, because you're not entitled to get damages for those infringements. So the point here for your clients, mark. And the point for you for lawyers, if you happen to be getting patents, design patents, if you're a patent prosecutor listening to this program, and you're getting design patents for your clients, when that patent issues, make sure you send a letter to your client saying, closing your file, congratulations, we got you the design patent, here it is. Make sure you tell them that they must mark. Because down the road, if you don't tell them they must mark, and then they come speak to a litigator, and we tell them, yikes, you have a problem, you can't really stop these people because you didn't mark, they're going to be very unhappy, and they probably end up going and talking to you and your insurance carrier because you just didn't tell them to mark. So telling people to mark is critical. That's our design patent overview. And you see we've sort of run the course across products and industries, technologies, and it brings us to our final slide here of our conclusions that we'll walk through briefly here. Number 1, design patents have powerful remedies in terms of the total profit disgorgement. So really strongly consider advising clients to look into the value of securing them. Don't assume that you can't get one even on the design, even if you think it's sort of like building upon 3 or 4 other design ideas that were out there and you've sort of taken them together and just built on it and you think, oh, it's not really patentable. It may be. Make sure your clients speak to a patent lawyer. And again, once patent issues, make sure they're advised to mark. Very, very critical. Now, once you are going into litigation, remember this ordinary observer test, it's a really powerful test for plaintiffs fundamentally because it's a strict visual comparison. And if they look really kind of similar to an ordinary observer without doing some hyper-mechanistic, legalistic type analysis of the different differences, courts are likely to look at it and just say, yeah, it looks the same, we'll let a jury figure it out. And that puts a defendant in a very awkward place having to argue on defense these technical differences to a jury. Much harder. The scope of damages in this area, it remains undecided at some level as to, do you get the profits on, for example, the whole shoe or just the profits on the sole of the shoe? If the design is only on the sole, do you really get the profits on the upper? Who knows? Jury gets to decide on that multi-factor test. At least that's the test in the district courts right now until the Supreme Court eventually resolves it. But assuming that multi-factor test stays, again, no easy out for a defendant there. Another reason it's a powerful tool for a plaintiff. And then, as we saw in the Columbia case, the doctrine of you trying to find prior art to invalidate a design patent has been tightened, again, in a way that's kind of pro-plaintiff friendly, which makes design patents ultimately potentially more lucrative. Thank you for watching. As ever, if you have questions, please email me. Thank you.